Judicial reforms are long overdue in Nigeria. We have gotten into an era now where judges give judgments that are inconclusive. At first, I thought it was the electoral process that we started hearing the term inconclusive. Now, judgments are inconclusive. And I'll cite two examples. The case of the Labour Party judgment, where the two parties are interpreting it what suits them, and the case of this judgment where both parties are interpreting what suits them. And I'd like to ask a big question. If a judge says a suspension was excessive, what also stopped the judge from giving a definitive order that the person should be recalled? Because by the judge giving an advisory order, that's the loophole they have taken now. So when judges give judgments that leave loopholes, it deepens the problem in the country. And that's why I see we need judicial reforms. I was with somebody yesterday that was talking to me about since when they had been advocating for judicial reforms. It's not been today. We need a total overhaul. Payment of judges, what constitutes the judge, people that get on the bed. We need a total overhaul in our country. And that reform also should go to the lawyers. We saw senior advocates of Nigeria. It was a day of disgrace and shame. Last Friday, a couple of Fridays ago, go on TV, say that the judgment said, when they had not read the CTC, that they should apologize to the Senate. That the contempt filed against Natasha, the contempt judgment given, was an apology to the Senate. And you see, I remember I said it here 1,000 times, that the apology is to the court. I've been vindicated. I don't talk if I don't have my facts. I'm a man of empirical facts. I don't quote what is not necessary. See, I have read through the CTC. I have read through the cross appeal. What the Senate have filed is a cross appeal. They filed a cross appeal against Natasha's prior appeal. And I know all the arguments. What is Natasha saying? Senator Natasha Akpoti is saying in her appeal. She said, were the processes followed by the courts to be able to arrive at a judgment of contempt against her? She said in that for contempt to happen, two things must happen. The court must first serve something called a Form 48. If you do not reply to Form 48, then a Form 49 happens, and the whole process becomes against you. There's something called the Sheriff's Act that gives procedural guidelines for contempt. So she's challenging invariably the contempt. Then the Senate, what is the Senate and Senator Akpabio challenging? They are challenging the judgment that even said that the limit of the suspension was excessive. Because I've also read their cross appeal. And they said they are also challenging the fact that the court has no jurisdiction to dabble into matters that align with the National Assembly and all of that. They also said that the procedure was not good enough because in their case, a lot of the dispute resolution mechanisms were not exhausted in the National Assembly before the case came to courts. So they are saying the judgment should be struck out. And that's why I say it behoves on the judiciary. Two parties now. The first part against Senator Akpoti, he has gone to challenge her part. The second part against the Senate President, he has gone to challenge the part that concerns him. So we are both going to the Court of Appeal on a matter that has persisted for a while. Why we are going to the Court of Appeal is because enough clarity was not made as regards what transpired in the first judgment. And the Senate clerk was right. It was an advisory. You wonder that after somebody had used very hard words on the Senate, you should not remove your member for that long, it's excessive, you would only imagine a declarative judgment up next. But we didn't see that. After you said what somebody was doing is wrong, then the next thing that followed was, at your discretion. So the clerk of the National Assembly that used that lacuna was also right in the writing. But in all of these cases, they are now up to the appeal courts. We'll now go through another round of litigation. But please, this is a clarion call for judicial reforms in this country. We cannot allow this country to continue this way without due judicial reforms.
Now, I think that we need to be careful, again, about issues of precedent that we set here. Because as much as that CTC, in essence, is saying it upholds the sovereignty of the Senate, we can't dabble into separation of powers as a suggestion as and when it's convenient for us. This is the problem. If we're running a nation that upholds separation of powers, and the judgment in essence, the CTC in essence is saying that, well, the Senate has its rules and the Senate should follow their rules. These are my suggestions. No problem. However, there are cases where the judiciary is allowed to intervene in the National Assembly affairs. And one of those cases is when there are fundamental rights, the violation of fundamental rights. And those include when there are excessive or overreaching outcomes on the Senate floor, of which the judge said so in her CTC. She wrote both excessive and she wrote overreaching as well. And if I'm to read the statement with the CTC verbatim, at the final paragraph 12, it said she finds that the Senate has the power to, and I believe should, recall the plaintiff and allow her to resume representing the people who sent her there to represent them. So the question is, if the judge feels so strongly about this, and the judiciary does have the power enshrined in it to intervene when there are issues concerning fundamental rights, why did the judge stop short of doing that? I think these are the questions that we should be asking. We can't start crying separation of powers and listing the rules, because part of the CTC also listed the various rules of the Senate that were violated and so forth. And that is not an issue of dispute, the issue of seats and so forth. Fine, let's say that has been settled. But ultimately, we are all in agreement that her time has been served. It's excessive, it's overreaching. So the question is, why can we not go the extra mile to ensure that something compelling can be done to reinstate this injustice that the judiciary also agrees has been perpetuated? It's not a figment of anybody's imagination. The judiciary has said that there's an injustice. So what is the job of the judiciary if it's not to rectify injustices? These are the questions.